Good evening, sir.
Good evening.
Good evening, everyone. I am Pranjal Wankhede from Corona Remedies Limited. As you know, that Corona Remedies amongst the top five gynecologist company in India. And being a responsible organization, we at Corona Remedies always support and participate in different scientific programs such as a CME and webinars. Corona is serving gynae fraternity as a dedicated academic partner, and every time we bring a new topic with the latest update with the expert opinion. This time, we are initiating a new series of webinar on a different medical legal aspects. This time, we have our first program of 2024 is on a Consumer Protection Act in Nightmare. It's a series of medical legal problems with subject expert Dr. Gitendra Sharma. I welcome Dr. Gitendra Sharma sir once again. Dear friends, we are pleased to have Dr. Gitendra Sharma as an expert faculty for this webinar. He is a practicing gynecologist and obstetrician in Ahmedabad for 30 years. He is a MD in Obs and Gynae with a medical legal counselor. He has done his LLB with 15 gold medals and topped in Gujarat University in law. He is the author of books like Law in Obs and Gynae Practice, Consent in Obs and Gynae, and Law a Doctor Must Know. Dr. Gitendra Sharma has given more than 1600 lectures and 10 oration all over India. Dr. Gitendra Sharma was a vice president of Foxy in 2022 and 2023. He was the chairperson of Ethics and Medical Legal Committee of Foxy in 2017 to 2019. He was a president of AOGS in 2016 and 17 and hosted AICOG in January 2017. I'm sure this webinar will help you to all of you. So I request Dr. Gitendra Sharma, sir, please to proceed for your webinar. Thank you, sir.
Thank you, Pranjalji, for kind introduction. And at the outset, I would like to thank Corona Remedies Private Limited for giving me this opportunity to be with the viewers for this very good subject, that is CPA a nightmare. So today we are going to discuss why Consumer Protection Act has become a nightmare to our fraternity members. So, Pranjal, my slides are moving.
Yes, sir.
Okay. So, dear friends, we all know that we are passing our whole day like this. Every patient is a potential resident. And doctor, while in OPD, has to protect himself by applying different ways. Whenever we start our lecture on any medical legal topic, we always say two things. One, ignorance of law is no excuse. And an ounce of prevention is worth a pound of cure. That means prevention is better than cure. CPA, a nightmare. Say, I will feel that my lecture has succeeded if you will see me in your dreams today. So that is CPA, a nightmare. In 1995, that was an unfortunate decision of VP Shanta versus Union of India. And in that case, medical professionals were brought under the purview of Consumer Protection Act. And after this judgment, the new talk is of producer and consumer. So according to that talk, he who pays the piper calls the tune. So that means he who pays will decide that what treatment he or she wants to undertake. Let us see what is the relationship in between doctor and patient. So now, after this CPA is been included, there is as soon as patient enters in the hospital, there is an implied contract in between doctor and patient. And according to that implied contract, it is the duty of doctor to provide reasonable care. And that care should be of certain standard according to their skill. Success cannot be achieved in every case. Many times, success and failure depends on the factors beyond control of even professional. But the duty remains. Whenever doctor fails to provide the duty, that is duty to care, And due to this breach of duty, if some damage occur to the patient, that damage is compensated under Consumer Protection Act. So under Consumer Protection Act, the damages are to be settled, and second, for deficiency of services also, the damages or the compensation can be awarded. Let us see what is the meaning of standard of care. We all know that Consumer Protection Commission do not have always a medical person. So how a non-medical person decide that what is the standard of care? Standard of care depends upon the circumstances. Standard of care depends upon the educational status of a person. So person to person it differs. But in medical practice, standard can be established by either something which is given in textbook will be considered as standard, something which is published in some index journal will be considered as standard, something which is taught by the teachers in medical colleges will also be considered as standard, and something which is accepted by the peer groups. So these are a few example by which the standard can be established. Let us understand what is negligence. It is very simple to understand. Negligence means to do what a normal prudent doctor won't do in that circumstances. So that means normally no anesthetist will ever give general anesthesia with full stomach in a non-emergency patient. But if an anesthetist give anesthesia, general anesthesia with patient full stomach, then it is definitely a negligence. Or omit to do something which a prudent doctor will always do. So let us see the example. Suppose a patient comes with the penicillin injection. Normal prudent doctor will always do a test dose before giving this injection. But if without giving test dose, if this injection is been given by the doctor and patient dies of anaphylactic shock, that is considered as negligence. So it is very simple to understand what is negligence. Now, why this CPA has become a nightmare? Because we as a gynecologist rank first, because maximum cases under CPA are filed against gynecologists. So we are number one, and that is really something to do with that. Maybe because we are treating two persons at a time, mother as well as fetus, and we are dealing with the physiological condition rather than pathological condition. So delivery is considered as a physiological condition. So in physiological condition, if any complication occur, it is never palatable. So dear friends, we should not practice too fast. And we should not practice too slow also. If you do go too fast, that means we have to go with the standard practice. If we go too fast, means something which is not given in textbook. If we do that thing, we can definitely be in problem. And we should not be too slow in our practice. See, this gentleman wants to do suicide. And what he has planned, he is planting this plant and watering the plant. He will wait that plant to grow so that he can do suicide. So you should not be too slow in your practice. So that means you have to increase your level of understanding and level of knowledge day by day by attending regular continuous medical education program, that is regular CM is to be attended, and you should increase your knowledge. Otherwise, you will fall behind. You have to follow the basic principle. What is the basic principle? Ladies first. So here this gentleman has broken that principle, and see the result, what has happened. So we should follow the standard practice. We have seen that in Consumer Protection Act, normally the causes of complaints are, they are not basically the negligence on the part of doctor, but in most of the cases, the rude and inhuman behavior on the part of doctor or their staff members with the patient or the relatives attract the problem. This problem can easily be avoided. Criticism by another doctor. See, this is a serious thing which we should always think. In 40% litigation, Doctor is behind doctor. So if somebody takes treatment from your hospital and then goes to another doctor for second opinion, if that doctor give certain kind of expressions which will convey that something wrong has been done by the previous doctor, and that will attract the problem. See, we all know that there are black sheeps in all the fraternities. So medical profession is also one of the profession where black sheeps are always there. And these kind of black sheeps always harm the whole fraternity members. So uh, we should find out those black sheeps and we should do something for them. So we have to think about all this, and we should from today onwards avoid criticizing our colleague. If we will avoid criticizing our colleague, we can definitely be able to avoid these kind of problems. So whatever is the fraternity, but we all doctors should live like this. Poor communication is another reason. So communication counseling should be done properly. Proper time should be passed with the patient in your consulting room. It is said that if you will pass less time with the patient in your consulting room under AC environment, then in future you will have to uh, compensate that time in the court of law where there is no AC at all. Misrepresentation again is one of the cause. High fee and poor care. See, in the era of corporatization, where uh, the in a corporate hospital, the quality of care is high. But suppose we are running a single doctor hospital where we are not providing that kind of quality of care, but if we are charging like that, so if we try to charge high, then high fee and poor care can attract the problem. Complications and deaths, disabilities are never acceptable. And whenever there is complication of operation or treatment, whenever there is disability or death, it is never acceptable by anybody. Dear friends, why CPA is a nightmare? Because medical litigations are increasing in number constantly and steadily. Every year, there is 104% rise in the litigation against doctor. And I can say that nowadays, more than 10% to 20% doctors are being served with notice by one or the other patient. Not only that, but the amount of compensation is also increasing day by day. See, in 1999, 1998, that was the 1995, that was the case of V. Chandrasekhar against Apollo Hospital, Chennai. In that case, the maximum amount of compensation awarded was 19 lakhs rupees. It rose to 1 crore rupees in the case of Prashant Dhananka against Nizam Institute of Medical Sciences. And in 2013, as we all know, that the case of Anuradha Saha against Amri Hospital, Calcutta, and in that the amount of compensation rose to 5.96 crore rupees. With interest, it rose to 11.5 crore rupees. And this amount of compensation is really nobody can expect that these kind of compensation will ever be acceptable by any medical fraternity members. Under Consumer Protection Act, it was said that it was defined that who is consumer. So it was said that the person who is not paying at all to the doctor cannot be considered as the consumer. But even patient who have not made any payment remain a consumer in a hospital where some patients pay and some do not. So suppose you are uh, catering 100 patients a day and you are charging 50 out of them and you are not charging at all to other 50. So the patients to whom you are not charging at all, they will also be considered as your consumer. So we must understand that even if you will charge a single patient, all the patients to whom you are treating will be considered as your consumers. When CPA was enacted, particularly in the case of VP Shanta versus Indian Medical Association in 1995, it was said that uh, only outright cases of Consumer Protection Act will be decided according to this Consumer Protection Act. In the case of VP Shanta, it was said that the cases where no evidence is required or no expert opinion is required to be produced, only those kind of cases can be decided in Consumer Protection Commission. But surprisingly, this judgment was overruled in J.J. Merchant versus Srinath Chaturvedi's case in 2002. And according to this judgment, even complicated questions of facts requiring evidence of expert can be decided by consumer court and need not be referred to civil courts. So surprisingly, the consumer courts where the medical professional is not there as a sitting member can also take decision in cases of negligence, which requires even expert opinion to decide. There is a maxim. It is said that actio personalis moriter cum persona, means a personal action dies with the person. But surprisingly, CPA don't leave you even after your death. It is said that substitution of legal heir or representative as party to complaint in event of death of the complainant or the opposite party. That means this Consumer Protection Act does not leave you even if after your death. So suppose a case is filed against a doctor and that doctor dies in between. Even then, this case will continue against the legal heirs of the doctor. This is something surprising. So, if we go to one case of Dr. Tarun Bandwal, he had to pay 2.5 lakhs rupees. Their legal heirs had to pay 2.5 lakhs rupees as a compensation even after death of that doctor. So, this is something surprising. And if doctor is not in condition to pay, the compensation will be recovered as land revenue. So compensation ordered by consumer courts recoverable as arrear in land revenue. So it is something really difficult to understand. Section 3 of Consumer Protection Act says that provisions of CPA shall be in addition to and not in derogation of any other law for the time being in force. That means there is one doctor, but the cases can be filed in multiple fora simultaneously. So, as we all know, that criminal case can be filed simultaneously with consumer case. Then complaint can be filed in different commission, Human Right Commission, Women Right Commission. The complaints can be filed in State Medical Council, National Medical Council, and under new Clinical Establishment Act, complaint can be filed in CMO's office or we can say at Chief Minister's office or Prime Minister's office. So only one doctor, but he has to defend himself in multiple fora. And people nowadays file multiple cases against doctor so that doctor under pressure will settle the case outside the court. There is definitely a problem with defense. What is the problem with defense? Many state commission do not upload their judgments in website. So an informed study and audit of these judgment cannot be conducted. And that is the reason that as we do not know what kind of judgments are coming at different state commission and national commission level, so it is very difficult to defend ourselves. There is no uniformity at all in decision in similar cases. We have seen that different kind of judgments are coming in the similar case. Similar case of PPH, in one case doctor is exonerated and in another case the compensation is granted. So mop left in abdomen, in one case criminal liability has been settled against the doctor, while in another case doctor has been exonerated or acquitted. So there is no uniformity of decision under different circumstances by different courts. So it is very difficult to understand that how decisions are being taken. Quantum of punishment is dependent on complainant and not the crime. So normally, at least in criminal prosecution, the punishment is dependent upon the crime, not the complainant. But here, the punishment is dependent on the complainant, how much he is earning. So applying the multiplier method, if somebody treats a big industrialist like Ambani's, then what kind of compensation he will have to pay? Nobody can even imagine. So it is very difficult to apply this multiplier method for the quantum of punishment. And as per new, as per decisions which have come nowadays, it depends on the complainant and not the crime. So whether your negligence is small or big, but the compensation will be awarded according to the level of the person who has been affected. So can we charge the patient according to the level of the patient? Answer is no. So why these type of compensation? It is not understandable. See, we are living in the confused nation. Why we are living in confused nation? Because in the case of Mukhtiar Chand versus State of Punjab, it was said that Ayush people cannot treat patient with allopathic medicine. In another case of Poonam Verma versus Ashwin Patel, in that case, it was said that any homeopathic doctor, if doing allopathic treatment to the patient and if patient dies, it amounts to criminal negligence. And a case of it amounts to gross negligence. Multiple such decisions are there. I cannot quote much about, but why we are into confused nation? Because even after these kind of judgments by different courts, different state government has issued guidelines and passed even certain laws that certain bills which allows Ayush people or homeopathic or Ayurvedic doctor to treat the patient with allopathic medicine. This is something surprising. In India, there is no cap to compensation. See, in many states of America, there is capping of compensation under Consumer Protection Act. But in India, there is no cap to compensation. So we all know that in V. Chandrasekhar's case, 19 lakhs were given in 1995, while it amount rose to 1 crore rupees in Prashant Dhananka's case. Then it rose to 5.96 or 6.08 crore rupees in the case of Amri Hospital versus Anuradha Saha's case. Even in the case against government hospital, that is the case of V. Krishna Kumar versus State of Tamil Nadu. In that case, 1 crore 73 lakhs rupees compensation was granted against the government hospital. So, dear friends, there is no cap to compensation in India, and that is worrisome for a doctor. See, in 1995, when this law was Consumer Protection Act was rather doctor were included in Consumer Protection Act, many doctor as an intelligent people, they took legal, they did the legal degrees and they started protecting their fraternity members. But surprisingly, on the very next year in 1996, there was a case filed against one doctor saying that doctors should not be allowed to be advocate or to defend their fraternity members in the court of law. That was the case of Dr. Haniraj L. Chulani versus Bar Council of Maharashtra and Goa. And Supreme Court gave this decision that nobody can profess two professions at a time. So this judgment barred enrollment of doctors with LLB degree into the bar unless they give up medical practice. So if any doctor want to be a legal expert and want to protect their fraternity members in the court of law, then he has to give up his medical degree and he has to register himself in bar council. Only then he will be allowed to present the case of a doctor. Now, even the prisoner can get the compensation. See, in the case of Nina Ranjan Pillai versus Union of India, in that case, it was decided that somebody may be prisoner, but even a prisoner, if not given proper treatment, then he can also claim the compensation. Compensation can be awarded more than the originally claimed. So this is also surprising. See, it is said that even mother does not give without asking. But here, there are many examples. In the case of Raj Rani and others, where a patient claimed only 3,200 rupees as a compensation, but he was awarded 5 lakhs rupees. So compensation awarded can be more than originally claimed. This is surprising. No fixed criteria of interest charged on the compensation. See, in the A.K. Mittal versus Sri Neelam Gupta's case, in that case, the amount of interest was 18%, while in the case of Kunal Saha versus Amri Hospital, the interest rate on the compensation awarded was only 6%. So there is no uniformity at all. In certain cases, it is 6%, in certain it is 9%, in certain cases it is 12%, and in certain cases it is 18%. And it is difficult to understand. These are the discretionary power with the court. Interest on compensation awarded can be more than compensation. See, look into this case only. This is the case where the compensation awarded was 5.96 crore rupees, but with interest it rose to 11.5 crore rupees. So sometimes the decision is too late. So the amount of interest becomes more than the compensation awarded against the case. There is no clarification whether it is a simple interest or compound interest. So there is a vast difference in between simple and compound interest, and there is no clarity in law that whether this interest which is on the award, whether it is a simple interest or compound interest. No negligence, but compensation is granted. Again, it is surprising. In many cases, the different commissions give compensation on gratuitous basis. See, there was a case of Mukhtiar Singh versus Kasturi Devi. And in that case, a judgment came against doctor in district forum. And doctor had to pay 5,25,000 rupees as a compensation. Now that doctor went into appeal, but he deposited money in the district forum to go into appeal. In state forum, he was acquitted, and it was said that there is no negligence on the part of doctor. Then that patient went into National Commission. In National Commission also, the judgment came in favor of doctor. So ultimately, doctor has to get back the compensation which he already paid in district commission. But when the case went into National Commission said that, see, the young son of this complainant has died, and as her daughter got married, he withdrew that compensation amount from the district commission in emergency, and whatever he has withdrawn should not be taken back. So surprisingly, without negligence, doctor had to pay 5,25,000 rupees to the patient. There are multiple such examples. In case of Dr. Ved Prakash versus Nihal Singh, in that case, the compensation was awarded as a goodwill gesture. And we have come across in our 20 years experience that many cases decided against doctors are because that they are being indemnified. So suppose some doctor has indemnity policy, then court thinks that if you will give a few amount of compensation to the patient, it is not going to harm you. So please give this much compensation. So compensation on the compassionate basis are being awarded, and sometimes as a goodwill gestures are being awarded to many patients. And this is something surprising. Consumer Court declares that a case of gross negligence. See, again, it is not a job of a consumer court to decide, or consumer commission to decide whether a negligence is a simple negligence or a gross negligence. The job of consumer commission is to decide whether there is negligence or not, and what is the damage, and that damage is to be compensated. But again, in the case of Anil Kumar Mittal, in that case, the consumer court gave a remark that although we are giving 4,95,000 rupees compensation, but as this negligence is a gross negligence, so over and above that, 10 more lakhs rupees are to be paid by the doctor to the complainant. So that kind of judgments are beyond our understanding. And after this judgment, as the gross word was used by the consumer court, that patient filed a criminal case against the doctor. So, dear friends, certain things are done by the consumer commissions which are not acceptable. Doctor can be held liable for advice given on phone or advice given through third person. So again, it is surprising. See, in the case of M. D'Souza versus Mohammad Ishfaq, Justice Markande Kazu and Justice Loda gave the judgment. And in that judgment, it was said that no prescription should ordinarily be given without actual examination. So, without application of mind, without examining the patient on telephone, you should avoid prescribing the medicine. You can prescribe the tendency to give prescription over the telephone, except in an acute emergency, should be avoided. So, we should avoid prescribing medicine on phone. Otherwise, we can be held liable for the same. See, we have heard that in government hospitals, most of the time, the treatment to the patient are given free of cost. And that's why government doctors and hospitals are not covered under CPA. But it is not so. There are news in the newspapers. Patient treated free of cost, also consumer, and can sue. These type of misleading advertisements we can very often see in different newspaper. In the case of Pavitr Singh versus State of Punjab, that was the judgment against Samrala Hospital in Punjab. And in that judgment, doctor had to pay compensation for failure of tubal ligation. So, multiple judgments are there. Doctor had to pay 3 lakhs rupees in this case of Pavitr Singh. In Jagjeevan Pal versus PGI Chandigarh, in that case also, doctor had to pay compensation. And there are multiple examples of cases filed against government hospital where government hospital had to pay, or the doctor who are working in government hospital had to pay compensation. In the case of V. Krishna Kumar versus State of Tamil Nadu, again 1 crore 73 lakhs rupees judgment was awarded against the government hospital. Senior and junior residents are not even left out. So there are multiple cases filed against junior and senior resident. One of the junior and senior residents in the case of Mehsan Danji Gadvi, that was filed on 18th January 1997 for a death during tubal ligation operation. And in that case, senior and junior residents were made the party and they had to pay 2 lakhs rupees compensation. Multiple cases are going on against junior and senior doctors of PGI Chandigarh or AIMS Hospital. So I am not going into much detail, but we must understand that as the cases are going on against the junior and senior residents, so it is always advisable that junior and senior resident should also take indemnity insurance. ESI hospitals are also covered now under CPA. Previously, it was thought that ESI hospitals are also doing treatment free of cost. But in the case of Kishore Lal versus Chairman Employee State Insurance Corporation Hospital on 8th May 2007, an award was given against the ESI hospital. So they are also not immune. Status of army hospital. See, again, it is said that army hospitals are doing free treatment. There was a case of Sudha Garg versus Union of India, in which in army hospital, that was the case of carcinoma tongue. And in that case, doctor had to pay 12.5 lakhs rupees with 10% interest to the by the army hospital. In another case of Base Hospital Delhi versus Alka Srivastava, in that case, doctor missed the fetal anomaly, and for that, doctor had to pay 5 lakhs rupees compensation to the complainant. So, dear friends, even army hospitals are not immune. And under CPA, vicarious liability is always there. Why I have shown this picture? Because the responsibility of keeping in place is always on the highest button when lower buttons are not working. So in the similar way, whenever the treatment is been done by the doctors, then the senior most doctor or the hospital is always vicariously responsible for the act of doctor. What are new things? See, we all know that new Clinical Establishment Act is been enacted in many states. It has been enacted now. So in that, according to this new Clinical Establishment Act, it is said that you have to treat patient in emergency. So Clinical Establishment Act Rule 12(2) forces doctors to stabilize all patients who come in emergency. So what happens if a cardiac patient dies in a gynec nursing home? So I can say that Bhagwan hi Malik hai. And Sone pe Suhaga, what is that? CPA is been repealed in 2019 and new CPA, that is Consumer Protection Act 2019, is been enacted. Multiple things in that act are to the great surprise, which is not acceptable and which should not be there. No qualification of sitting members, no selection committee, nomination of all the members by central government. This is kind of thing which is very difficult to counter. Central Consumer Protection Authority will be there over and above Consumer Protection Commission, and they will be empowered to levy 10 to 50 lakhs rupees fine for advertisement and for unfair trade practice. This is also surprising. So we all know that this Consumer Protection Act was passed in Lok Sabha on 20th December 2018. It was published in Gazette by central government on 9th August 2019. So these are a few things which you can see. The CPA rules are being enacted and came into power on 20th July 2020. So these are all the things which I will like to show you, that on 20th day of July 2020, these rules came into force. And what is new in this rule? Let us discuss. See, we all know that laws are made in parliament and they are being construed and interpreted by courts and they are implemented by the courts. So whenever any question arises regarding the law, then court has to go into the legislative history. And particularly in Consumer Protection Act, when this 2019 Act was enacted, there was discussion done in Parliament at the time of framing law to be referred. So, when this law was made, let me clear some certain confusion. This confusion was the reference to the word healthcare. In 1986 Consumer Protection Act, healthcare word was not there. It was added in draft bill 2018. But when this draft bill was produced in Lok Sabha and Rajya Sabha, this healthcare word was removed from the CPA bill 2018. And now when this act is enacted, this healthcare word is not there in Consumer Protection Act 2019. So when we go through this definition of section 2O, that was the definition of service, in this definition, healthcare word is been removed. When we go to this, I am not showing you the discussion in the parliament, what happened, but I can say you that when discussion were going on in Rajya Sabha and Lok Sabha, the health minister at that time, Ram Vilas Paswanji, he discussed many things and he categorically mentioned in parliament that we are going to remove doctors from the CPA. The reason is that he has clearly mentioned that what is the reason of removing the word healthcare and removing doctors from this and from the ambit of CPA is that if doctors are being put under CPA, then doctors will do defensive practice and doctor will go advise unnecessary investigations to protect themselves from the litigation, and this will increase the cost of the treatment. Multiple such discussions held in the parliament, and after that it was assured by the Ram Vilas Paswan ji, the then health minister, that we are going to remove doctors under CPA. See, after this act was enacted, the doctor still remained in under CPA. Although Indian Medical Association also gave, rather they rejoiced that doctor are being removed. They gave press note also that doctors are now no more under CPA. But even after that, multiple courts have uh, decided to continue to take the cases against doctor under CPA. Now, Medico Legal Action Group filed a PIL in Maharashtra High Court, and that saying that doctors should not be included in CPA, because these kind of discussions were held in Rajya Sabha and Lok Sabha, and healthcare word is been removed from the bill, and now in Act healthcare is not there. But surprisingly, that PIL was dismissed by the Maharashtra High Court, and they were not ready to listen anything with cost. So this to file the PIL, 50,000 rupees fine was imposed on Medico Legal Action Group. Let us see what are a few new things which have come in this new CPA, and that is important to understand. See, in 1986 Consumer Protection Act, there was provision that pecuniary jurisdiction, where the value of the good or services and the compensation, if any, claimed. So the pecuniary jurisdiction was dependent upon two things. One is value of the goods or services, and the compensation claimed, if any. So that means, suppose patient has paid to the doctor only 10,000 rupees. But if that patient claims more than 1 crore rupees, then that case used to be filed directly into National Commission. So that was the case in 1986. And the pecuniary jurisdiction was in District Commission, the cases up to 20 lakhs rupees were filed. The cases where the compensation demanded was in between 20 lakhs to 1 crore rupees, they used to be filed in State Commission directly, and above 1 crore, where compensation demanded was above 1 crore rupees, the cases used to be filed in National Commission. But now, as per new Consumer Protection Act 2020, the word compensation claimed, if any, is missing. So that means pecuniary jurisdiction is now only dependent upon the value of goods or services. That means no patient, at least I can say the rare patient, will pay more than 50 lakhs rupees or 1 crore rupees as a bill to the doctor. So the value of the goods or services can never be more than 50 lakhs rupees in most of the 99.999% cases. So that means almost all cases will be filed in District Commission first. When this act was enacted in 2020, the pecuniary jurisdiction was up to 1 crore rupees. All cases used to be filed in District Commission, where the value of services is up to case in State Commission, and more than 10 crore, it is in National Commission. But in the same year, in December 2020, that is now changed, and for District Commission, where the value of services is less than 50 lakhs rupees, then the cases will be filed. This amendment has been done, and this pecuniary jurisdiction is changed from 1 crore to 50 lakhs, from 10 crores to 50 lakhs, and to 2 crores for State Commission, and for National Commission, more than 2 crores rupees. Local jurisdiction is also expanded. See, in 1986 law, there were only three provisions: that patient can file a complaint against doctor where doctor is working, or where doctor is residing, or where patient has taken the treatment. But a new section, subsection D, is been added in this, and it is said that the complainant now can file a case against doctor where the complainant resides or personally works for gain. So suppose I am living in Ahmedabad, in Gujarat, and I receive a patient from Kerala. And if that patient is not satisfied with my services, and if that patient wants to file a case against me, then the patient can file a case in Kerala District Commission. And district commissions are normally run in a local languages. Now tell me, how can I defend myself sitting in Ahmedabad in Kerala, and that also in a local language? It is really impossible. And no district commission, rather I can say very few district commission have facility of online discussions. So it is very difficult now for doctors to protect themselves or to defend themselves in different courts, because to appoint lawyer in different state to keep watch on that lawyer, that what is going on inside court, to understand that in a local language, it is near to impossible. And these kind of I can say sections or amendments should never be done, should never be entertained, rather. And we must do something for these kind of things. A new thing has come in law, which is unfair trade practice. And it is said that failure to issue bill or receipt will fall in under the definition of unfair trade practice. Disclosure of personal information given in confidence, unless required by law or in public interest, will also be considered as unfair trade practice. Over and above that, excessive pricing will also be considered as unfair trade practice. Now, what is the meaning of excessive pricing? Nobody knows. It is nowhere defined that what is excessive pricing. So this is a, I can say, smart move by government to control the price in the medical field. Central Consumer Protection Authority, over and above state, district, and national commission, there will be another authority that is known as Central Consumer Protection Authority. And it is said that this authority will directly be appointed by the government, and multiple powers are being given to the Central Consumer Protection Authority. This will regulate the matters relating to violation of rights of consumers. So that means wherever there is consumer right is been violated, all cases will be decided by this central authority. Unfair trade practice. So that means misleading advertisement, excessive billing. These are all the cases which will fall under their jurisdiction. And false or misleading advertisement. So these which are prejudicial to the interest of public and consumer, and to promote, protect, and enforce the right of consumer as a class. So these all matters will fall in the jurisdiction of Central Consumer Protection Authority. And multiple powers are being given to this authority, and they are allowed to pass on order that compensation of, or they can award compensation from 10 lakhs rupees to 20 lakhs rupees. And if their order is not followed, then a penalty which may extend to 50 lakhs rupees. So we all know, dear friends, that there are multiple agencies already there to deal with false or misleading advertisement. Now there is no role of that agencies. We all know that Advertising Standard Council of India was already existing, which was taking care of this misleading advertisement. But now there is no role of ASCI, and everything regarding misleading misleading advertisement will be decided by Central Consumer Protection Authority, and they directly will give the judgment and impose penalty of 10 to 20 lakhs rupees for that. If a person fails to comply with the orders of the district, state, or national commission, he may face imprisonment. So previously there was a provision of 1 month imprisonment and 2,000 rupees fine. But now this penalty is also been intensified to 10,000 rupees and up to 3 months imprisonment. If a person fails to comply with the order of district, state, and national commission, he may face imprisonment not less than 1 month and may extend to 3 years now. See, or a fine not less than 25,000 rupees, which is extendable to 1 lakh rupees. So previously it was 2 to 10,000 rupees fine and 1 month imprisonment, but now it is 25,000 to 1 lakh rupees fine, and the imprisonment is 1 month, which may extend to 3 years. Non-compliance of Central Consumer Protection Authority order, this will attract imprisonment up to 6 months or a fine up to 20 lakhs rupees or both. For misleading advertisement, again, the provision of 10 lakhs rupees punishment is there, and this may extend to 50 lakhs rupees and imprisonment up to 2 years. So these kind of punishments are not, I can say, a welcome thing in Consumer Protection Act, and doctors should not be dealt in such a way. Previously, it was the case that in previous Consumer Protection Act, there were things available that if you lose your case in district commission, you can file an appeal in state commission. If you lose your case in state commission, you can go to national commission. And if national commission gives some judgment and you are not happy with that, it was the appeal was available in Supreme. You can go into appeal in Supreme Court. But according to new Consumer Protection Act, only one appeal will be allowed unless some question of law is involved. So only one time. See, if you lose your case in almost all cases are going to be filed in district commission now. And if you lose your case in district commission, you have only one chance to file appeal in state commission. Unless some question of law is involved, you will be allowed to go into appeal only once. So you can go into state commission only. Now we all know the level of judgments which have come from the district commission and state commission. Now you won't have any opportunity to go to national commission or Supreme Court into appeal. One good thing which was mentioned in this new Consumer Protection Act is mediation cell. So in this, there is provision of mediation, but that also is been restricted. Mediation cell does not allow to compound or to settle your case outside court in case of grievous hurt or death. So if the case is in relation to grievous hurt or death, then mediation won't be allowed by the Consumer Commission. But if there is a simple injury, only in those cases, mediation cell will allow to settle your case outside court. So dear friends, this slide is very near to my heart. This says that today's thank God that whole is not on our end. This is the way of dealing. I feel this picture is a reflection of the mindset of our profession. Sooner or later, we will all sink if we do not unite and take decisive remedies. Dear friends, I give you one example. Recently, Bharatiya Nyaya Sanhita is now a bill has been put in the parliament. And we all know that Section 304A, where there was only punishment up to 2 years provision was there, which was increased. And the amount of compensation was also been rose according to the law, new law. And it was objected by the transport people. And within 20 minutes, I can say, of the decision taken by them to go on strike, the government was forced to take back this amendment in this particular bill. So, dear friends, we can change the scenario of this world if we unite. If we don't unite, then we are going to suffer again and again with such kind of laws. We all know that ART Act, we all know the MTP Act, we all know the different kinds of acts which are becoming stringent day by day against doctors, and we have to do something for that, and we have to unite ourselves. So hope I am not confusing you much. And being a doctor, if a case is filed against you, or if you receive any notice, and if you want to be remain calm and relaxed like this, then you should always, before answering a single first notice, I can say, before answering to the first notice, you should take proper medical advice from your senior. You should take legal advice from the legal person. And nowadays, the another creature is there, that is medico legal person, who bridges, because the medical person does not understand the language of law and legal person does not understand the language of medicine, and that's why the medico legal person bridges the gap in between medical and legal person, and take medico legal advice and relax yourself. Whenever law catches you, see, the medico legal person always have something in his hand so that you can be free from the law. Thank you. Thank you very much. If ever you need me, I will always be around you. Keep me in your heart, and no need to keep my card below your pillow. Have sweet dreams. Thank you.
Thank you so much, sir. Thank you so much, Dr. Gitendra Sharma, sir, for your valuable uh, details which you have given regarding the this new topic of this new year, especially. Because, sir, as per our series, we are getting very positive response across the India. I just gone through our videos also, so lots of people are watching those videos on YouTube. So it's a really informative session for all of us. Even as a pharma people, we are also got to know about the Consumer Protection Act in the nightmares, which will be helpful for us to discuss with the doctors. Okay. So thanks a lot, sir, for your valuable support again. And
Thank you.
thank you all the participants and all the viewers for your patience. Thank you so much, sir. Thank you.
Thank you, sir. Thank you.